that, you know, you have a big answer to, you can always, you know, just sort of type out if that's possible, or type, you know, type in your comments. What do you think are the challenges that healthcare professionals face on a day-to-day basis in your role as healthcare professionals? What are the challenges that you face? So 1 minute, put something in the chat. Let's just get this conversation going. Tell me what you think is your problem, the problems that you face on a day-to-day basis that sort of catch your attention. So I'm going to mute for 2 seconds while we just give a little. If you want to raise up your hand and have a chat, why not? But otherwise, you can just put the answer into the chat box and let us know what's you feel you're faced with on a day-to-day basis as an healthcare professional. I think I see some answers in the chat, maybe. I'm going to try and see if I can. Yes, somebody put hostile work environment. That's really interesting. That's something that's obviously we all face, you know, on a day-to-day basis, depending on where you work. And then some of us face the opposite of that. So we have a very good work environment, we have a lot of people, but I'm really asking you to think in terms of privacy, in terms of data protection, in terms of processing personal data. What kind of problems do you think, you know, you face on a day-to-day basis? So I'm going to continue sharing now. Yeah, and I'm hoping we can all see the screen that I'm sharing. Yes. So what I've put here is different things, really. Sensitive personal information. This is something that you find, you know, healthcare professionals face because you have to deal with patient data. You have to deal with a lot of confidential information. And then you also face the need to justify disclosure. Sometimes you find yourself having to say things to maybe authorities about patients. Even these are things that you would normally not be allowed to say. And you have to make that disclosure. You then need to justify it because of the need to preserve confidentiality. Another thing you face is consent in the healthcare profession. How much consent do you need? When is consent necessary? How do you challenge it? And then what about patients that are not able to give you consent? What do you do in that respect? So these are, you know, a few of the problems that you find in the healthcare sector. Secondly, we transition from there and then we'll go to the concept of data protection itself. What exactly is data? Bearing in mind that within hospitals, within the healthcare sector, you know, going from either different aspects, either radiology to neurology, or just generally going through all the components of the healthcare sector, we find data. Data is very critical to the role of healthcare professionals. What is data then? I've put here that data is information that has been translated into a more convenient and accessible form. You know, it's easy to move and it's easy to process. In the electronic world, data is represented by bytes and, you know, binary digits with a value of 0 or 1 stored in a CPU. This is just general definition of what data itself is. So you know now, with all the technology we have around globally, what's exactly we mean by data. And people say things like, data is the new oil, data is the, you know, the new normal and all of that. But again, is just sort of situating us into that realm of data is really, really important, and it is something that we all want to preserve. We have to say at this stage that data is not a fundamental human right. Privacy, on the other hand, is a fundamental human right. And we're going to see that in a little bit, just to give us a bit of introduction as to what we're going to be talking about later on. So we know that data is not a new thing. It's always been collected. We all have data. We've always either given out our data, either, just have some data shared in a system. The difference is technology. That is what makes it prominent today. So because of the capability of computer to store, process, and disseminate information, it poses significant threats, especially in the healthcare sector. Imagine if all the data that we had in hospitals, became public and people got to know about our health. This would be something that really pose a lot of threat to us, as a country. So the difference is technology. It's not the case that data hasn't always been available. Now you find the situation a little bit different as well because of the curation. Due to technology, you can make data digital. That's why health is becoming digital at the moment, because in the past it would be a paper-based, sit down and see a doctor, have everything written in papers. But now you find that it can be done online. And this is something that can, within a click of a button, you can actually see a virtual doctor, get a virtual prescription, buy your medication online, and there you go. So the difference is technology. What sort of data would you collect? So I've put a few things here. I should have asked it as a question, but again, you find that you can collect data of what you buy, when you buy it, your health, your religion, your sexuality, financial details, trade union membership, who you vote for, your biometric data, which is, your passport information, if, airports, where you go, and a little bit of profiling if possible, just necessary for your own data protection. So you get a lot of data that will be collected, and this list is not exhaustive. This is a long list that you can, you can populate with anything that relates to you. Like I said, data privacy itself is a good starting point for data. And for you to understand the kind of data that the sensitivity of the data that healthcare holds, you have to understand the origin of data itself, and that's privacy. So I'm not going to bore you with this, but then the key thing are two important legislation. That's the Universal Declaration of Human Rights and the European Convention on Human Rights. Both legislations say the same thing. Article 12 of the UDHR says that no one shall be subjected to arbitrary interference with their privacy, family, home, or correspondence. So privacy is the word. Article 8 says the same thing. Everyone has the right to respect their privacy, family life, home, and correspondence. So we all know that this is something that has a lot of privacy undertone, and a lot of people confuse privacy with data protection and vice versa. I must stress that privacy itself is the umbrella term for all things private. Data protection is only an arm of privacy, and that is something that we need to understand. And then at this stage, I wouldn't go into a lot of details as to the background of privacy, because data protection is what we're really going to be nailing today, because there's a lot of things that privacy entails, looking at mental privacy, cognitive liberty, a lot of issues that are outside even data protection itself. And a lot of things can be considered data. Now your thinking is beginning to be considered data, your cognition, things that you think about, if a machine, if an algorithm can actually predict your thoughts, then it is beginning to be the case that this machine is actually taking your data from you, because from that prediction, it can analyze what you do yesterday, or what you did yesterday, or what you do tomorrow. So these are things that are really, really important parts of privacy. But in terms of data protection, one legislation that really brings a lot of attention is the General Data Protection Regulation. And the General Data Protection Regulation is a legislation that the whole world is now buzzing about. That's the reason we have, the draft Nigerian Data Protection Bill of 2020, because of the global discussions around privacy, ethics, and responsibility, hence data protection, understanding the legal and ethical implications of businesses and organizations, research institutions. All these discussions naturally warrant a change in our approach to data protection globally. So data protection in terms of GDPR is something that I would like us to closely look at today, but not from the perspective that this is the norm and this is what we should be applying directly in Nigeria. No, we have to be aware that even as healthcare professionals and healthcare organizations, your understanding of this underpinning global legislation would determine how you operate as an institution. But then what I would like to also stress is the fact that this is an international legislation that really demonstrates best practices, but the institutional peculiarities and the jurisdictional configurations of Nigeria would mean that it might be adapted slightly differently. Take consent, for example. Consent, which would come to in a bit, is something that is really, really globally, defined as unequivocal and explicit accent to an action, particularly data processing. But take Nigeria as an example. In order for people to be able to consent, a lot of things must be in place. They must know what it is. But what about language difficulties? Language difficulty may not be a global challenge. It's a peculiar challenge of, a number of countries, to which Nigeria is no exception. So we have to understand that some issues in the GDPR may not directly be applied in our own local context because they're just two different countries, but the overarching principles would always apply. We're talking about principles of data protection particularly. So that is something I wanted to put out there for us to sort of understand. Now, this general data protection regulation is a really, really interesting regulation that has been getting me busy since 2015 or thereabouts. And I have to just let you know that there was a timeline to this. Prior to the GDPR, as it's normally called, we had the European Data Protection Directive. And that was a very interesting directive. The directive sort of gave a lot of opening to privacy and data protection globally at an EU level. The trouble is it was getting out of date because technology was rising at a fast pace. This directive started in 1990, and a lot of institutions found it very useful globally, even in healthcare. After a couple of years, as technology began to advance, there was the need to revisit it. And that is why we're where we are today. So I've put there a table that gives a sort of timeline as to how the GDPR came into force. In 2012, there was the draft proposal, there was some agreement in 2014, negotiations, it became published in 2016 with a 2-year transition phase. So the legislation actually came in 2016. The transition meant that we had 2 years to implement it for organizations, tech institutions, public health organizations to be ready for it. So there was a very big thing in the UK that would be, are you GDPR ready? Are you ready for the GDPR, even for hospitals? So that is something that I wanted us to have an idea about. And that's everything that I've put here in the next slide. One thing I have to stress is that the GDPR actually regulates personal data across Europe. So it talks about data that is processed for European citizens. It's a global effort to sort of harmonize all the data protection that takes place throughout Europe to provide a single digital market that would enhance consumer confidence. That is the reason why we have it. And there has been different calls for perhaps Africa to have, a single would mean that we are at right time. We're in the right time and doing the right things now in terms of GDPR. Now, the GDPR specifically talks about personal data, and we're going to be talking about what personal data is in a minute. But one thing that I have to stress is the GDPR does not regulate anonymized data. And I put it there. Anonymized data or anonymization is irreversibly preventing identification of data subjects. So the GDPR only looks at data that is possible for people to identify, identified and identifiable data subjects. So that is what is regulated by the GDPR. And of course, in the healthcare sector, this is data that we deal with on a daily basis. So if you work in digital health, even a traditional health sector, you are effectively covered by law, you know, with the GDPR, depending on where you are. Pseudonymization is the opposite of anonymization, and that is what falls within GDPR, data that can be re-identified. So having said that, I have a question, which is something that obviously I've actually said. And the knowledge question is, which data is not considered under GDPR? I mean, at this stage, I think if you want to scan the QR code, you might be able to get the question up. But otherwise, if you answer the question using the poll, that will be fine. So on your Zoom link, there should be an opportunity for you to sort of answer the question using the polls that we've provided. So I'm going to stop sharing, and I would sort of invite people to answer, if you can, the questions that you find in the poll. Can we see the question? Can we all see what's on the screen? Can we all answer this question if we can in like a minute or two? Yeah? Are we getting any responses? I'm going to give you a few seconds, and I've just read the chats and someone wants me to put my slides in full screen. Okay, I'm going to do that. Yeah? Let me start sharing again. So if you're able to see this, yeah? So again, this question is very, very simple, and it is simply anonymized personal data. So we go to the next stage, which is conceptualizing the main provisions of the GDPR. And the first thing I have to ask is, when does GDPR apply? The General Data Protection applies to processing of personal data, and that is what I've said before. Now, what is processing? Processing or data processing is any kind of operation or set of operations that is performed on personal data. So whatever, either, you know, analyzing personal data, either storing it with some technology, you know, whatever you do with personal data to make it useful, curating personal data, you know, uploading it on some softwares, these would be considered as processing. And then the personal data we're talking about is any information that relates to an identified or identifiable person. So it doesn't necessarily mean a name is given. It doesn't mean that you have, you know, so much information about it to be able to identify the person. It might just be a code. So in the UK, we all have, you know, national identity numbers, NI numbers. We all have codes. These are personal information that would help to identify us, and it is what we would call personal data. So, and I've put a definition there for identifiable, any information. If a natural person can use any means likely to be able to identify that person, then it is actually personal data. And if you begin to think in your own role as an healthcare professional, you perhaps have a lot of ledger numbers, a lot of, you know, codes that you put at the end of people's names, so that ordinary people would not really identify those people, but you know who they are. That's still personal data. So if my name is Simi Akintoye and somebody simply calls me 14, the number 14, and a group of people actually know that that number means myself, then number 14 is effectively personal data for me. Yeah? And these are the examples of personal data that we're talking about. So names, telephone numbers, email addresses, ID numbers. I've just talked about, the number 14. Account-related data, such as human resources data, if you're working in unemployment, location data, your IP address, all these would be personal data. Now I have to now come to something we call special category personal data, special category. And some legislation also call it sensitive personal data. So there are two layers actually for personal data. There's the personal data, which is the personal data, and there is the sensitive personal data. So the ones that reveal race or origin, political opinions, you'll be surprised that political opinions actually is personal data, sensitive personal data, religious beliefs. So am I Muslim, am I Christian, am I practicing, trade union membership, and so on. But what actually concerns us today is genetic data or data concerning health. And these are sensitive personal data. They are data that require extra level of protection, extra layer of protection according to GDPR because of the sensitivity of the information that it possesses. And in digital health, you find that this is the type of data that we're most concerned with. We do not deal with just normal personal data, but we actually deal with data concerning people's health. Do these patients or does patients A have Alzheimer's disease? Does patients A have mental illness? Do they have this scan results? These are information that is really, really sensitive and would require extra layer of protection. And I've explained here what health data is, just in case people are here thinking, but what is health data? What is covered by health data? Any data pertaining to the health status of a subject that reveal information relating to the past, current, or future physical or mental health of the data subject. So it's not only, oh, but that's happened last year. That was their test results last year. It's not relevant. Let's just share it. No, it is still personal data, either past, current, or future. So I want you to be really, really, really careful of how data is handled. It doesn't matter whether the patient is even past. It would be personal data. But I must also say that the GDPR doesn't regulate data of deceased persons, but that's something else. I'm not here to discuss that. So again, I've also put specific, just in case we're still wondering, what exactly is it? It's information derived from testing or examination of a body or body parts or bodily substance. So we're looking at DNA, we're looking at blood. People's blood can actually identify them if someone is a sickle cell carrier, and that can really lead to identification of that person. The person's blood is actually personal data. One thing I must say is that the GDPR stresses and broadens the category of what personal and even sensitive personal data is. So genetic data, biological samples, information on the disease, disability, disease risk, medical history, clinical treatment, the list goes on and on, physiological or biomedical states of the data subjects. So it is really, really interesting that this is nothing to do with, whether or not it was done in your hospital or something you stumbled upon. It's actually data that concerns that person, regardless of how it was collected. It is sensitive personal data. And this is interesting. So I want you to begin to sort of think as to how this, how you actually use this on a daily basis in your organization. And particularly genetic data, anything that has to do with their DNA, RNA, from analysis, you do not need a name. So it's not really important whether you have the person's name or not. What is important is that you have information that could lead, and it doesn't even matter if it was you that can de-identify it. So if this is sort of blood results and you can't even read it. You've got no clue what it says. It doesn't matter whether it's you that you are able to re-identify it or not. The fact is, if it's in your possession, it is sensitive personal data. Interesting. So that's what, personal data is covered by the GDPR. I wanted to sort of show that because, it's something that really, really concerns those in the health sector to understand the ambit to which the GDPR goes. Another thing that the GDPR does, which is something that I feel relates to why we're doing this today, is the wider territorial scope of the GDPR. What do we mean by this? The GDPR applies to processing of personal data in the context of the activities of an establishment. And there are several cases here, but I've decided not to bore you with some legal cases because the GDPR actually applies to the activities, and that's the key word, the activities of an establishment. Google, for example. Google is not located physically in terms of their headquarters in Nigeria. And the case in question here is the Google Spain case. And I haven't mentioned it because, but it is really interesting when you realize that some of the activities that are covered by the GDPR could be what you do. So depending on where your establishment is, if you're established in Nigeria, but then you process data of people that actually live in the United Kingdom. The United Kingdom is still covered by the GDPR. Thankfully, we're in a transition phase before Brexit. Interesting. So yeah, when you find yourself processing data of people that live within the EU, you will be covered by the GDPR. Companies not established in the EU are still caught up by the GDPR if they conduct activities, offer goods and services, monitoring of internet behavior, and process data that relates to data subjects that are within the EU. Simple as. So it's nothing to do with, oh, but why is the GDPR? Why do we have to do anything relating to the GDPR in Nigeria? The main thing is how wide, how global are your activities? Who are your patients? Who are your customers? Who do you partner with? Who are your sponsors? Who do you speak to? How do you relate to them? So these are the things that you need to ask yourself as health organizations to be able to understand critically whether or not you're covered by the GDPR. And in many cases you are, except you're not Y2K compliant, as is being said, but it's something that you really need to be, you cannot get it wrong by being safe. So it's better to be safe and to treat your activities as though you deal with people or you hope to deal with people that are covered by the GDPR. And this is really interesting. So I hope that was really useful for some people that do not know about this. So quickly we go to data protection principles. And these are the things you'd find in the GDPR. I've tried not to put too many things in here because this really is an awareness, and I understand people may not have prior knowledge of data protection, but the critical things are the data protection principles. So data must be processed lawfully. That is what Article 5 says. And these principles are really, really relevant in your day-to-day operations. These are things that you cannot overdo. The more you're getting more data knowledge with regards to what you do, the more your operations are in aligned with privacy and data protection. So your data has to be processed lawfully, fairly, and in a transparent manner. So this is called the lawfulness, fairness, and transparency principle, for example. You have to make sure that you have a lawful basis for processing the data you're processing. Forget the fact that you're an health organization and you have a hospital. People come to you for good healthcare, or people go on your platform if you're into digital health, they log in on your website because they want good health information. However, you must still make sure that you're processing their data lawfully. It's not enough that I'm a doctor, I finished from the University of Lagos with a first class, so they should know. No, you still have to demonstrate that lawful basis for processing, and it has to be fair, it has to be transparent. The second one is data must be collected for specified, explicit, and legitimate purposes. Again, it doesn't matter. some people, and I've seen a number of countries where doctors are or healthcare professionals are like, you know, mini gods, because they can literally tell you, sit there and you sit there, bring your right arm and you bring it. But the fact remains that if it's not specified, explicit, and legitimate, it contravenes the GDPR. Not further processed in a manner that is incompatible. So the purpose limitation, you only collect data for what you need it for, nothing more. It's none of your business where these people live just because it's close to your house and you want to see whether or not, oh, are you going my way? Let me just see where you live online. Oh, so yeah, you can give me a lift. This is really, really irrelevant. And a lot of us do a lot of things without, you know, we don't know anything different. But actually, many of it in developed countries would really, really contravene GDPR because of, you know, things like purpose limitation, for example, data protection principles in general. So you collect the data, either patient records, only for what it's needed. The third one is the adequate, and data must be adequate, it must be relevant and limited to what is necessary. So the data minimization. So now there's a purpose limitation, but then a data minimization. You only collect what is necessary and use it for the exact purpose that you've stated that you would use it for. Data must be accurate. So if someone do not have this address, they don't live here anymore, you can update their address and then discard the previous address, because there's no point keeping two addresses on your system for one patient. So once you get the information of where they are or what they do, or maybe their children and all of that, you update it and then discard the previous information, except you have a data retention principle, which is something else. But otherwise, I shouldn't log in on your system or on your computer if you're in a hospital and find three addresses of one patient. This is really, really irrelevant, because it's not only so much information. Consider if somebody was, you know, a really, really, let's say, serial killer, for example, someone who wants to trace this person, you know, to find out where they live, previous addresses and all of that, and even the possibility of fraud. Someone else can use this previous information to sort of gain, you know, access to these people or bank details. Anything can happen, and to think that it all started from one person's mistake of not actually deleting the previous information of that person. And it's even really, really punishable by the law. So data must be kept accurate. The other one is data must be kept in a form that which permits identification of data subjects for no longer than is necessary. So this is a storage limitation. You do not store data for no longer than necessary. If you don't need it, delete it. But then I must tell you that there's a data retention principle that you may have. Maybe by law, you keep your data for a number of years. As long as you have a policy around that, you can delete the data from your system, but then have backup, which you can keep for a few years. That's not a problem. But as long as you do not need it immediately, do not keep it on your system, so that if somebody comes in, they cannot find irrelevant or no longer needed information. So that is what we need to stress. So your patient records needs to be kept up to date. The ones that are no longer needed, you can curate them, i.e. put them in a folder, make sure they're accessible, and then take them away from the immediate system that you use. Once you get to the end of your retention period, the law says delete it. You don't need to keep it for no longer necessary. Why would 10 years patient record still be on your computer immediately? And I'm saying that immediately, using that word immediate, because here in the UK, we find that the NHS has all our records. If I go to my doctor now, they have everything about me, even from 2006 or 7, you know, but this is following their retention principle and what they do in terms of providing public health and national security. So that is something you have to understand as an organization. How long do we want to maintain data of patient records? Okay, if we're keeping it for even 20 years or 50 years or even till eternity, we need to make sure that it's not easily accessible. There's some technical and organizational measures that we need to put in place for that. So that's the storage limitation principle. Data must also be processed in a manner that ensures appropriate security, and I've said that, integrity and confidentiality. Don't make it readily accessible, and don't make your password one. You know, I read somewhere that the worst type of password, which is easily used by people, is just password. You go on any computer, just press password, you can open that computer, or password 1, password 2, or just find the person's date of birth and put it in. You can so make sure that it is as confidential and as secure as it is, so that you can preserve the integrity of that data. And this is a pictorial analysis of what I've just been saying. You know, security, these are the things that you find in personal data processing. You know, it must be fair, lawful, transparent. There must be purpose limitation, data minimization. It must be accurate, storage limitation. You must be accountable. In other words, to be able to demonstrate. And I must say that accountability is one of the new, is actually a new provision of GDPR, which says you must be able to demonstrate compliance. So it is actually a principle that as organizations, including digital health organizations, you're actually able to demonstrate that you're meeting the requirements of GDPR. So that is also something else that you must be able to do. And I've sort of put some diagram there with regards to sensitive data, telling you that sensitive data is a no-no. You mustn't process sensitive data except you fall under different categories, which health and social care is one of them. So in health and social care, you would find yourself obviously processing sensitive personal data. So this is, for those of you that want to take notes, this is just giving you broad categories of the kind of data that we're talking about. And there is a lot there, but I don't want to go into too much detail because this is really introduction to these principles, giving you the basic and critical concepts that you need to be able to align your activities as digital health organizations or health professionals, as the case may be, to privacy and data protection. I'll quickly stop sharing to see if I have any questions, because I really like to take questions. And yeah, I will see. Okay, some questions I might take maybe later, but yeah, put your questions in the chat and we will try to answer them as we go along. So let me continue sharing my screen. We've talked about all these principles of personal data processing, and I just thought I'll put a diagram that sort of encapsulates everything we've talked about. And I must say here that you find that accountability is a very key one in the GDPR. You must be accountable for what you do. It's not only doing it, it is being accountable for it, and you must be responsible for it. And as I said before, demonstrate compliance to this principle. So I should be able to walk into your hospital, to your company, to your platform, if it's online, and say, how do you comply with GDPR? How do you ensure your GDPR compliance? And you should be able to tell me, this is what we do. This is what we have. We have a data mapping exercise that we've conducted. We've done this, we've done that, and this is how we comply. So you should be able to demonstrate that even to the authorities, should in case somebody, God forbid, reports, you know, to the authorities. Yeah. So what do you require before you process personal data in healthcare? And even generally, what do you require for data processing? The first thing is consent. And we would have heard about that, oh, loads and loads of time. Consent. There are various bases for processing of personal data. One of it is consent. You cannot process personal data unless the person has told you to use it. The second one is for the performance of a contract. You know, you might have signed up for something. If I register in a gym because I want to get fit and I signed up into the gym, they have a 1-year contract with me that they're going to provide some services. They can always use my information. If I'm employed in an organization, they would have my own information and they will use it because they are performing their side of the contract employment. What about legal obligation? If you have a legal obligation to use it, you will use it. Vital interest and public interest. Vital interest is if it is actually in the interest of the person. If, for example, someone collapses, you know, in the middle of the street, and you sort of notice that this person might die, in the person's pockets you find, you know, contact information. You cannot stand there and say, oh, excuse me, Mr. X, I know you're dying, but do you give me consent to use your data? Can I put my hand in your pocket and get out your name? Or can I use your phone to phone 911? You have to do what is necessary because this is a matter of life and death. You don't need consent to be able to save somebody that is drowning, for example, in a river. You go in, you carry the person cannot sue you for, doing things that you should not be doing. So it's quite interesting to see that there are quite a few, options that you have for processing personal data. Now, legitimate interest is something I think for healthcare, and consent is something we have to be really, really interested in. If you want to achieve a legitimate interest, how do you do that? If you're a hospital, or you're a digital health platform, or you're a chemist or a pharmacist, you need to be able to analyze, to be able to use the personal information of people to deliver your services to them. So that is a legitimate interest. If it's aligned with what you do. I am a hospital. As a hospital, we have to process people's data. We have to look at their test results. Yes, they will give us consent, but even if they didn't, we still need to know, because it is our job to save lives. We have a legitimate interest here. So that is something that I would really need to stress. For healthcare professionals, consent and legitimate interest is the key. And in fact, you find that people even say, that always try to use a legitimate interest. And that's what I'm going to be saying in the next slide. So the next slide is talking about consent. What is consent? This is very, very interesting. And I've been to a lot of, conferences that say that make sure you don't use consent, because when they withdraw consent, then it becomes a big thing if you've already used the information. Consent itself is any freely given, specific, and informed indication of wishes by which the data subject signifies his agreement to personal data relating to him being processed. And there's a lot of words here. Any freely given, specific, informed indication of wishes. And if you're a medical doctor, this will not be new to you at all. This would be, oh yeah, I know about this already. It must be informed. It's not the case that they just pick up the document and sign it at the bottom. Sign here, sign here, sign here. No, it's about read it. Do you understand? And if the person doesn't speak English or the language in which the document is written, for us in Nigeria, it's about what language do you speak? Do you need an interpreter? And then you make sure they understand the content of the information they are signing or some printing. It must be specific and informed. They must make the decision based on your understanding. It's not enough for you to just explain to them and say, they understand. You must explain to them if you need to, but then ask them to affirm it by maybe putting a signature or some printing, or giving their proxy to actually put an information to sign on their behalf. It must be voluntary. There's no way it should be obtained with coercion. So these are the attributes of consent. It's not actually that complicated. And I put a picture there because it's not really complicated. And I'm surprised to even see that big names like Google, and recently Google got fined in France over 50,000 euros, if I'm right, if that figure is still correct, for actually not making consent as explicit as should be, because of the nature to which that consent was drafted. So it became the case that when people go on the website, it's appeared as if the legal basis for processing was legitimate interest, when actually it was indeed consent and it wasn't explicit enough. And they got fined by CNIL for that. So quickly, this is to talk, take us back the questions that we've been, the issues that we've been talking about in the last over 45 minutes now. This is a second knowledge question that I thought I would just throw there to people. And it says, which processing principle requires the controller to explicitly describe the reason for which data would be processed? So if you want to put some answers there and we can look at it, I will give 2 minutes, and I'm hoping that we can all, discuss it. It's just going by what we've talked about. Which of the processing principle would require that the controller must explicitly describe the reason for which the data will be processed? Description, yeah? I will give 2 minutes for that, and I hope that we can discuss it soon. Yeah, so I'm going to continue sharing now. I believe we've all answered the question. And let me know if you want me to say anything else. I'm just going to share back my screen. So a lot of people have said purpose limitation. I think that is correct. That is really good. I'm going to go back to where we were before. And the third question, which we have to answer quickly, it says, which processing principle requires that personal data must be up to date? So another knowledge question there for us. If you want the personal data to be up to date, which principle are we looking at here? So quickly, I will stop sharing for 2 seconds while we'll quickly answer this question. And then we'll go to the fourth one. I think we've done that, and I'll go to the final one. The final one says, which concept does the GDPR define as any operation or set of operations that are performed on personal data? So if you put that up in the poll, I think we should be able to answer that. Thank you. Thank you all for that. I think that's the end of the questions. The reason why I put a few of these questions here is because it's really important for us to understand what we're talking about here in terms of personal data. So yes, now we've looked at the 4 questions and I think we all got it. The second one was that talks about description is actually purpose limitation, because you have to give the purpose to which the data is going to be used, the purpose for which the data will be used. And then the third one, which we talked about, is actually accuracy. So data must be kept up to date, it must be accurate, and if it's no longer needed, like we said, it should be deleted. And the fourth one, thank you very much for that. And the fourth one actually is processing. Which concept does the GDPR define as any operation or set of operations performed on personal data? And that, of course, is data processing. So now we want to look at managing the rights of data subjects. So you now know that you are actually processing personal data. You're not just processing personal data, you're processing sensitive personal data as a digital health institution. How do you manage? You know the principles you have to follow, which we've talked about, all these data protection principles, you know, accountability, lawfulness, integrity, transparency, and the likes, data minimization, storage limitation. You know about these principles. How do you now manage the rights of the data subjects that you have? So managing it. So you have people that have given you their data because they consented to it, or you're processing the data because you're performing a legal obligation. How do you manage the rights that data subjects have? Because you must bear in mind that you do not have absolute rights over this data, especially because it is sensitive data. It is very important that you handle it following the provisions of the law, but then recognizing and acknowledging the rights that the subjects, the people whose data you're processing, the rights that they have. And it's get really, really interesting here. I'm going to stop for about 15 minutes so that we can take a break. We are halfway into the training, and that is really good. That shows that we're on time. You know, we might have even more time to take questions and all of that. So I'm gonna give it 15 minutes for us to grab coffee or take a drink, or, you know, just stretch out and reflect on the questions that we want to ask, put it in the chat, keep the conversation going live if you want to go on Slido, and just sort of reflect on what we've done, and then we can come back. I think the time now is 11:06. So if we come back around 20 minutes past or 22 minutes past, something around that line, so that we can sort of recap and then go to the next phase where we discuss managing rights of data subjects. So thank you very much, and I will see you all in 15 minutes.
Thank you very much, Dr. Simi. As she has said, we'll be taking a 15-minute break, so you're welcome to grab yourself a drink or a snack. And if you think of any questions, you can insert them in the chat box. So we'll see you guys in 15 minutes. Thank you.
Yes, we're going to start, and thank you all for sticking to us. I hope you had a bit of refreshing time to sort of digest what we've looked at, because there's a lot to take in, and I understand. I don't want to bore everyone by just, speeding on. Feel free to just cut along the way and ask some questions depending on what you want to know. So I hope that's been refreshing for everybody. I've been reading through the chats and I saw that, there's a comment around, this is the GDPR, how does it relate to the NDPR of 2019? We have to say one thing, and this is what I say all the time when I present, is understanding that the GDPR is the overarching legislation that actually started this conversation around, data protection regulation in the global age that we are. So many of the provisions that you find in NDPR, even in other data protection jurisdictions and the legislations that they've enacted, have sort of have a GDPR undertone to it. And that is what, we try and stress. Last year, I was in Ghana talking about data protection, and one of the facilitators, was asked this question, who was in Ghana, actually, they are Ghanaian, that, we don't even know about the GDPR. We want something in Ghana to look at. But the response he gave was, this legislation would apply to you if you are a business and you're a global business. So if you aim to sort of comply with the GDPR, you wouldn't have anything to lose. In fact, you have everything to gain, because you then just need to make one or two adjustments and then you're Nigeria ready, if you get my point. So in demonstrating international best practices, I believe the GDPR would be a good one to look at. There are peculiarities for Nigerians, which I did say at the beginning, and it is interesting for us to also do this do it alongside the Nigerian regulations. And if you're following the discussions around privacy and data protection, you'd know that there is currently a draft bill, and there's been some feedback that's been submitted. We also gave some feedback to the bill. So I believe that Nigeria is still really at its infancy in terms of privacy and data protection, but compliance with GDPR in organizations would place key companies, perhaps the ones in public health sector as well, and even digital health private companies, in a position where they can demonstrate this new transition in what they do. So it is really, really interesting that we understand from an international perspective what we can then apply locally in Nigeria using our own peculiarities and not just simply transposing the GDPR into law in Nigeria. And that is what I feel is giving rise to a lot of controversy now to data protection regulation in Nigeria, because of the attempt to want to transpose, developed countries' mechanisms into Nigeria, which is always different in terms of the local context that we find ourselves. So this is something that is interesting, but thank you very much for that question. And hopefully you would get more insights as we go along. So like I said, the third part of this, or the second half of this session, will be dedicated to managing rights of data subjects. Now you're very aware that you're dealing with personal data, and in fact, sensitive personal data. You know that you've got to have a legal basis for processing, which you probably already do. How do you deal with data subjects? They're not just a research, they're not just a patient to you, but they are individuals that have rights, and they will, trust me, they will be exercising their rights. People will come on your platform if you have a digital platform, and they would put complaints. They would say this, they would say that. And how do you manage this? How do you manage expectations? So to give you an update, and this is just a list of the rights. I thought I would let you see these rights because you need to be aware of it. There are various rights that data subjects can actually exercise. First is the right to access. Every data subject has the right to access data that belongs to them. They can simply walk into your organization and say, can you let me know or let me have what information you have about me? I want to see what you hold about me. And this is a right. So subject access request is something you'll be getting, where people would come and say, let me see what you hold about me. If it's an employment, if you're, employing people, maybe you've got your group of doctors, you can ask him. Right to rectify is also another right. And rectification is a right that is really, really interesting, because if a data subject comes and says, that is not correct about my data, please can you change it? You've got they have the right to give you, for you to rectify that information. Right to require erasure. And this is a very, very interesting one. Right to require erasure, the right to be forgotten. That's what people, always try and interchange it with. There's a lot of controversy around it, and I'm not unaware, is that the right word, of the controversy. A lot of controversies around, right to erasure is different from the right to be forgotten, and vice versa. The right to restrict processing. Okay, before we go there, I would take a minute for us to sort of discuss the right to erasure as well as the right to be forgotten. So the right to erasure is the right where they can actually say, can you erase my data? And this is very, very interesting, because what we must know is it doesn't give anybody the right to come to your organization and say, erase my data, erase it. Now listen, there's a difference. And people can withdraw consent. People can object to you processing their data. Why? Because, it's a right. Erasure is different from that. The right to be forgotten is different from that. It is not people objecting for you to process their data. Why do I say this, and why do I stress this? There is the mistaken discussion around right to be forgotten when people have your data and they're not meant to have it, or when patients come to the hospital, they say, erase all my data. That is different from when they want to stop you processing a particular data. The right to be forgotten is asking that an organization actually deletes everything that has to do with your data from inception, or even from a particular time, because the purpose for which that data has been entered into your system is no longer necessary. There's a purpose limitation, and the case is the Google Spain case. We have to understand the alignment of right to be forgotten and purpose limitation, because otherwise the rights would be applied by every single person. If you Google your name on the computer, for example, you would find your name coming up maybe on Facebook, because if you're on Facebook or Twitter or LinkedIn. You cannot write to these people and say, can you erase my data because I want to exercise my right to erasure. The reason why data would be erased or completely taken off is rarely given by courts. And if you want to, further information on the Google Spain case, you can Google the Google Spain case and you'd understand what that means. But it's really interesting that we discuss this carefully, because that doesn't give anybody the right to just delete my data, erase me, forget me, and all of that, because it is not absolute. It's not an absolute right. It will be used only when necessary. And in the Google Spain case, you find that the reason to which that man's data continues to pop up on the system is because of, his past on loans and unpaid debts and all of that. And it was becoming a problem for this gentleman. And he wanted Google to sort of erase that data so that it would no longer come up. Anytime somebody or companies enter his details, it becomes an issue because of the past. And that purpose is no longer necessary. That's what the court said. Because otherwise, you find that everyone would be using their rights. Oh, I have a right to erasure, so let me go to my mobile phone company and ask them to erase my data. You want to sort of delete yourself from the world, and that's not possible. That is something I have to share. So if you see patients come in and say, remove all my data, they can, they can actually stop you from processing it. They can object to it. It's a right. They can stop it. They can withdraw consent, but they cannot, in effect, ask you to erase everything that has to do with them, even on the ones that you've put on different platforms, perhaps the ones that you've shared, for public health reasons, because that would be practically impossible for you to do. So the right to restrict processing, we've talked about that. Data subjects can stop you and say, I don't want you to use my data for this. I don't want you to do, a patient can actually say that. It can restrict it and say, okay, I only want this, this, and this, not the rest. You can restrict it. They can object and say no. And that is, they do not give consent. They have a right not to be subject to automatic decision-making, profiling, and that is a big issue, when you try to use, their data to profile them, unless this is for the performance of a contract or consent has been obtained or is authorized by EU member state law. And this is what, obviously the GDPR says. Yeah. So the lack of decision making is something that would enable, a data subject to possibly seek redress or the existence of automatic decision making. If you want to profile your patients, maybe on a digital health platform, you want to make sure you use, their data to sort of do some analysis. They have to consent to it. It's not that you're not allowed, but they have a right not to allow you. And that is why we have all these cookies, privacy notices, and all of it. So that is something you have to be aware of. It's not automatic. The fact that they're on your websites or they're in your organization or your hospital does not give you the right to profile them and sell them medicines and try and advertise some things to them and say, oh, because you've come here for a heart checkup, we believe you need this. Except that profiling is actually necessary for the performance of a contract. If that's the case, then that's possible. But if it's not for the performance of a contract, if they haven't consented to it, if there's no authority that you've been given, you're not allowed to exercise that profiling. Then rights to data portability. So you have to be able to provide that data to them in a form that they can read it, that they can access it, and obviously the right to withdraw consent. They also have the right to complain to supervisory authorities. That's not fair, but that is a right, You might be thinking, oh, complain. They have the right to complain to supervisory authorities. They can report if they are not happy with what you're doing. What you can do is to manage expectations by also providing them an opportunity to complain to your own organization. So do you have a complaints procedure? Is there a way where they can complain without, without having to go to supervisory authorities? And if they need to go, are you giving them that opportunity? And that is a right they must have. So you should be able to have a complaints procedure that actually states, this is our own complaints procedure. This is how you complain to us. But if you're not happy, this is the authority you can complain to. Yeah. So this gives you the various rights that data subjects have. And then I must also say that, if you collect data for one purpose and you want to use it for another purpose, you need fresh consent, or you must inform them, the data subject, of the further processing, actually, if you're going to be using data, health data, patient data for any further processing. That is part of the reasons you've collected it in the first place, but it's not the only reason, and it's something that is now linked to it, but you need to actually inform them of the further processing. They also have, data subjects have the right to claim compensation, and this is interesting because in the GDPR there are different types of compensation. You know, they are, you know, depending on what you suffer as damage. But one thing that is clear in the GDPR is material and non-material damage. Article 82 talks about that and says that if you've suffered material or non-material damage, you can claim compensation. And if you have patients or people that you deal with that are in the EU, this is something they can use, because financial loss becomes immaterial as individuals are now able to claim for distress and hurt feelings, unlike the previous directive. Interesting, isn't it? Because you don't really have to have suffered a big damage before you can actually claim compensation under the GDPR. You can claim because you were stressed, because the data was lost, and because they breached your data, it affected you mentally. You don't have to have a damage that you can physically see. And it says there you can claim for distress and hurt feelings. So it is very, very important to see how enormous these punishments can be, you know, and how you want to make sure that you comply as much as possible to the provisions of the people that you deal with outside Nigeria. And I've got one question, I think just one question here. It says, who can obtain restriction of processing? And I'm going to ask them to sort of put that up so that we can just answer that in 2 minutes. It's just one question. And yeah. If you put that question up, please, and then people can get a chance to sort of answer that. Yeah, I think that should be fine. I'm going to continue sharing my screen. Thank you all for those questions, for answering the questions. And quickly, whilst we were answering those questions, I saw the chats and somebody was asking, you know, they wanted the full case, the Google Spain case, which I referred to earlier. And this is, you know, I've put that in the chat. There's also Google France. I mean, these are just abbreviations of long cases. So if I can find the Google France case as well, I'll put that up. But that's the Google Spain case, should you want to read it up. And I've got the facts of the case, which maybe actually I can share that. Maybe that would really help if people want to know a little bit more about Google Spain. I can quickly share that. I don't know if you're saying this, but just to give a little bit of information about the case, right? Because if I understand that people are interested into it, it's only fair that I give you a bit of information around it. So this is the Google Spain case, and you can find it online. So a Spanish newspaper made a publication in form of announcements regarding forced sale of properties arising from unpaid Social Security debt in 1998. Subsequently, the announcements were published in the order of Ministry of Labor and Internal Affairs. One of the properties belonged to Mario Constella Gonzalez, and that is the person who brought this case. In 2009, he made a complaint to the newspaper that whenever his name was entered online, it led to these announcements and asked for the data to be erased. This was rejected by the newspaper on ground that the publication has been on the order of Ministry of Labor and Social Affairs. So this was a newspaper that published information about this man who owed some debts in the past. Now, the information about the debts he owed was also published by the Ministry of Labor. Remember, this is a government agency now that has also published it. So we've got a newspaper that published it and a government agency that published the same. So he tried to erase that data. He asked them to erase the data from the newspaper company. And what they simply said is, we cannot erase it because this is public information. It's actually in the government website. So it's not information that is information that everybody knows. So he contacted Google Spain, because he was in Spain, and asked that his links to the announcements should be removed. So two things came up here, the right to erasure and also territorial jurisdiction. So the first request was forwarded to Google International, which is in California. So it's like Google Spain is a subsidiary of Google International. Google International is the headquarters. So they got the complaint, they sent it to their headquarters. And then the man complained again to the local Spanish authority for data protection. He said the same thing. You know, he wanted Google Spain or Google International and the newspaper to take off his details. Although the director of the data protection in Spain rejected the complaint against the newspaper, they asked Google Spain and Google International to remove the link, because what they said is that the newspaper probably published it following, you know, a public announcement from the government of the debt that this man owed. So they don't have a problem publishing it. The trouble is, why should it be on Google? What is the relationship of Google to this newspaper or to the government that would make them publish a private man's information? So they ordered Google International and Google Spain to remove the link. And guess what? They appealed, because the first thing Google International said is, we're in America. We're not covered by the GDPR. We're in California. The GDPR is an EU legislation. That has nothing to do with us. However, what they've said is what we actually said at the very beginning, that the activities of an establishment is what the GDPR looks at. It doesn't matter where your headquarters is, as long as you process data that relates to people that live in EU, you are covered by GDPR. Simple. So that is why for us as Nigerians, or people that live and have businesses in Nigeria, it doesn't matter if your business is in Nigeria, you know. So they've actually said that, and I don't want to read everything in there. But again, that's what they said to this man in terms of establishment. And then in terms of erasure, they actually said the purpose for which that data was there is no longer necessary. You can't keep punishing someone with their past by making sure that data is still there. Why must the whole world know? You know, it's a long time now and this data can go. Actually, it's not your place as Google Spain and Google International to publish it. The government can publish it, but nothing to do with you because you're not the government. So interesting. That was a very interesting case. And I'm going to stop sharing the slide just to digress, because, you know, somebody actually put that in the chat and I thought that would be interesting to give, you know, that background information. So I hope that was useful. I will go back to what we were doing before, and yeah. I hope you can see this. So thanks for answering the questions as well. Let me just, yeah. So quickly, we'll go to the last segment here on what we need to answer now, which is actors, roles, and responsibilities. Now you know what the law says, or almost everything, or nearly. You know what you should be doing in your organization, what the principles of data protection are. You know what the data subject rights are, so you know what they can do, you know, to you. What should you do then? What is your own responsibility as a healthcare professional, a digital health executive, in your roles, your day-to-day operations? What should you do? And this is really what I feel is the crux of this conversation, because it puts everything together, what we've been discussing, you know, in the last hour and a half, or nearly 2 hours now. What should you do as actors, and what are your roles and responsibilities? Definitely you share sensitive personal data, or you deal with, or you process sensitive personal data in your role in health and social care. Because this is data belonging to genetics, we've talked about that before, So you definitely have a lot to do in terms of what the law requires from you in your day-to-day job. And this is not to scare anyone and think, oh God, I'm going to go to prison for breach of data. I think the first thing you're doing now is the baby steps, the initial conversation, which is attending something like this, webinars like this, that sort of gives you that information, awareness, gives you that confidence to be able to use, to do your job properly in digital health space. Remember that the world is transitioning into a global data society. So for you to be at the forefront of that, for you to be, at the pace to which the global change is happening, the emerging data society that we're having, it will be good for you to know yourself, your role, your responsibilities, and what you need to do. Next question, are you a data controller or a processor? That's the thing you should first ask yourself. What do you do? What do we do in this organization? In this business, what do we do? Are we just a local pharmacy or a radiology company, or are we just doing scans, or do we have hospitals? Are we prescribing? Are we seeing patients online? Now, in the things that we do in digital health, especially in this period where we have uncertain times, particularly with regards to the COVID-19 situation, it will be good for every organization to rethink their actions, their core and integral operation. What do you do? Are you a controller or a processor? That is the starting point. Who is a controller? Who is a processor? A controller is a natural or legal person, a public authority, an agency, or any other body. And you can underline that word, any other body. It doesn't matter whether you've opened your company yet, or your company is just inside your computer. Any other body. And you might be liable regardless of what you call yourself. If you call yourself, I'm just an agent, so I don't know anything, which is what you do that determines what the law will call you. It's not what you call yourself. Yeah? So natural or legal person, public authority, agency, or any other body, which alone or jointly with others determine the means and purposes of processing personal data. So you determine the means and the purposes. And that word, I can go on and on in my role as data protection officer for the Human Brain Project. This is what I deal with on a day-to-day basis. Constantly liaising with organizations and scientists all over the world, trying to ascertain whether or not they determine the means and the purposes of processing. I mean, the EDPS, the European Data Protection Supervisor, has recently published a number of guidelines to help organizations to understand whether they determine the means and purposes of processing. If you use technology to determine it, you determine it. If you build infrastructure around it, you determine it. There's a long list, and that is, we were still looking at it because they're always keeping us on top of our toes. The one was published, I think, last November, and then just the beginning of this week, we stumbled on another one that was published on the 2nd of September on guidelines as to data controller, data processor in all sectors, particularly healthcare. Scientists that are using a lot of digital health innovation facilities, developing infrastructure, trying to advance neuroscience. Do you actually determine the means and the purposes of processing? And this is something that I would really employ everyone to sort of look at as a starting point in their organization, in what they do. Are we data controller? Are we processor? There's a third one, joint controller. Because if you look at the second line, it says the definition of controller, a natural or legal person, public authority, agency, or any other body which alone or jointly with others. So you could be doing it with somebody else. It's not only your company. There's another company that you jointly do it. If you use technology to determine the means or the purposes, not just to do anything else, but actually it must be determining the means and purposes. And that is, I can't stress that enough, because there's a lot of discussions, and myself and the rest of my team, we sometimes argue about this, So processor, if you're not a controller, are you a processor? Processor is new, actually. Data controllers, those that are responsible for determining how personal data will be processed. Data processors actually are those who process data on behalf of data controllers. So you could be actually liaising with a third party. Maybe you're liaising with a third party, maybe you're actually giving it like an agency to help you in determining the means and to help you in processing personal data. So you perhaps have a contract. So the idea is you have a written data processing agreement with a data processor who is helping you in your operation. So first and foremost, do you have such people in your organization? Is there a DPA, data processing agreement, in place? You need to actually take stock of what you do to understand where you are and what you need to do next. So this is really, really interesting. So do you use sensitive personal data? I mean, this already is, I believe, healthcare organizations and everyone here might be having that, it might be the case that you use sensitive healthcare, sensitive or special category data, health data, genetic data. Health organizations, what I put here, will need to be mindful that much of the personal data which they process will be special category personal data, which attract enhanced protections. You must have a legal basis for it. You must have technical and organizational measures in place for it. So apart from processing sensitive data, another thing you should ask yourself is, do you share personal data beyond your organization? Is it the case that there are some people you actually give that personal data to, maybe for processing or for use or for whatever transfer, international data transfer that is integral to your business? Do you have all the systems in place for that? Because you could be jointly liable for personal breach. You could receive fines from regulators, and your licenses, God forbid, could be suspended. And you then have no ability to process personal data. So these are things that you have to ask in your organization. Speak to the key people. If you're the CEO, or you're the ones that are actually in charge, of operational activities, make strategic decisions and liaise with professionals, privacy professionals, to be able to implement a working program for your organization, to be able to adopt the necessary skills and resources that you need for your day-to-day operations. So it's really important that you analyze this. But then some people might be asking, but how will we do this? This is also new. This is just too much. You must first determine, why are you processing the data that you're processing? Is it consent? Is it legitimate basis, which we have talked about before? Why do you have this data of these people? If you have their data because they've consented, they are your patients and they've signed a form, that's fine. Or there's a reason why they've actually given you the opportunity. Maybe because it is part of your core operations and you have a legitimate interest in that processing. That is fine. But remember that consent may be required, but sometimes it may be difficult when people withdraw their consents. But as doctors, as healthcare professionals, your legitimate business is actually a basis for processing data. When people come to you, you can use their data legitimately according to the law, because that is core to your business operation. But then one thing that is important, and as we've said in data protection principles that we looked at, is accountability. And I've put here that compliance with data processing principle is required for all processing, whether you are processing for legitimate business reasons or for consent reasons. You must demonstrate that you comply with the principles of data protection: accountability, storage limitation, purpose limitation, data minimization, transparency. You must make sure you actually comply with all those principles. You cannot say, oh, we cannot be accountable because actually we are hospital. Oh, we cannot store it we cannot demonstrate storage limitation because we are hospital. You must demonstrate all those principles of GDPR or of NDPR in Nigeria. Yeah. So this is a pictorial analysis of what I've just said. The questions you can begin to ask yourself as organizations: are the data we use for any purposes that we collect it for, is it adequate? Do we store it necessarily? Is the processing fair? Do we have technical and organizational measures in place? Does the processing involve transferring data to a third country? How do we do that? We'll talk about international data transfer today, but it is obviously something you might even need a professional advice on, to be able to say how you demonstrate compliance with international data laws of the country to which you transfer data, if you do. What if you engage some other countries to help you in your analysis as a digital health telemedicine online company? How do you cover that legally? Do you seek advice to be able to do that? These are critical questions that I think privacy professionals may be able to guide you towards, so that you're not, making money and then paying it in fine, or getting a bad reputation online when somebody writes a blog and says, oh, watch out for that company, my data was stolen, because you may not even know. Some hackers will go on your website and take all the data of your maybe patients or people that go on your website and use it for something else without your knowledge. How do you securely maintain your analytics online? So this is a pictorial, identify legal basis, make sure your data is up to date and all of that. So still under roles and responsibility, one key thing is a data protection officer. And you get a lot of questions around, do we need it? We cannot afford it. There's so much involved. The law says if you are processing large scale data, you will need DPO. If you are not processing large scale data, you may not, because people in your organizations, if you train them, give them the right awareness, they might be actually able to help you and make your organization compliant without employing an external DPO. And you can make an existing staff in your organization the DPO. The likely people to be DPO are always maybe like compliance officers, head of security, IT manager. You can make them the DPO as well. When I became the DPO for the Human Brain Project, I was initially an internal ethical consultant for the HBP. I was working, 10% of my time. I was still staff at the university, being a lecturer. So I wasn't a new member of staff joining the Human Brain Project. When I then became the DPO, it was just a transitional position for me, having gone through all the training and all the things that we had to do, get yourself registered and all of that. So it was just transitioning from my previous role then as internal ethical consultant into, data protection officer. So you might want to think about that. But if you're not a big business, you may not need to actually appoint a DPO. If you're a big business, you might need to either appoint or make somebody in your organization your DPO. Yeah? So if you don't need a DPO, it says here, organizations which determine that they are not required to appoint a DPO should keep a clear record of their reasoning in case this is called into question. Write it down. Documentation, documentation, documentation. Documentation is the key to everything, because once somebody comes and says, oh, we want to report you to the supervisory authority, you've not done this, you've not done that, you just say, this is why we are doing this. I mean, here in the UK, we have the Information Commissioner's Office. They are very, very strict. They will apply the law, but one thing they will do is to give you an opportunity to explain why you are doing what you are doing before they will come and say that they want to query you. So you have to be able to record. That's why it would be good to appoint, even if it's not a DPO, a compliance manager, an IT person, security manager, someone that will just take privacy on board. Mind you, privacy and security, privacy and IT, they are all different things. But if you want to maybe integrate it into one, because you're a small company, that's not a problem, as long as you can keep clear record of why you're doing what you're doing. And that is the most important thing. Yeah. Okay. So first, I will advise that we do what we call a data mapping exercise in your organization. What do we mean by data mapping exercise? After you've identified that you are either a processor or a controller, we need to have a DPO, either your DPO or yourself. If you are not appointing a DPO and you want to do it maybe by yourself in your organization, conduct a data mapping exercise. You must document what personal data you hold in this mapping exercise. The aim is to, what data do we hold? Where does it come from? Who do we share it with? Those are questions that we've also said before. You may need to organize an information audit around all these questions. To know what you're doing as an organization. Does our data come from Nigeria alone? Or the processing that we do, the transactions we do, the things we do, do we post things abroad? Do we have patients or do we have customers abroad? Organize this information, have an information audit across the organization with particular business areas that are relevant. Determine your lawful basis. Is our lawful basis for processing, is it relevant for data subject rights? Are we sure we are not breaching the law with the way we process data? Are we implementing the right data protection principles? Okay, we are doing this, but we are not doing that. Our data, we store it for too long, so we are not doing storage limitation. Oh, we collect a lot of information, so we are not doing data minimization. Do we do third-party processing? In other words, do we give other companies data to process for us? Other platforms, other softwares? Do we use softwares that we don't host to process our data? Are we sure we are not breaching any principle? Do we have agreement with these companies? Those are the questions you would need to ask yourself to be able to understand what's the current situation, like doing an environmental scan of your organization. That's what the mapping exercise is about. And it's really interesting because you find a lot of things. You find a lot of things that you may not even know. If you are the CEO and people just report to you, that mapping exercise will make you understand what is actually happening in your company, in your organization. And this is the starting point. So the ICO or even data protection authorities, before they will find any company, they will first ask what they have done. Here in the UK, you find that it's only companies that have recurrent offenses, or maybe really, really big offenses that they should have actually mitigated at the beginning. They are the ones that you will find that are having, problems with the ICO and getting fined. Yeah. So this data processing exercise or data mapping exercise is really, really important. And then when you've done that, you conduct a data protection impact assessment, DPIA. The DPIA is also interesting. It helps, it can be part of the data mapping exercise, but it actually is an exercise on its own. It's not, the only thing you find in data mapping. Data protection impact assessments. It depends on the kind of processing you're doing that will make you now determine whether or not you need to have a DPIA in place. If you are dealing with sensitive data, highly personal in nature, you are processing data on a large scale, you are a data controller, particularly if you are a data controller. Which is a legislation provision would really apply to if you are a data controller or a joint controller. Sometimes some data processors might decide to do DPIA too. It's not bad because it's international best practices. And before GDPR came into place, there is due diligence checks that, risk assessment exercises that companies actually do. Privacy impact assessments, it was called, before it became data protection impact assessment by virtue of GDPR. So when you are processing this kind of data, you might need to do a DPIA, and some companies or a lot of companies will not know how to. There are a lot of toolkits, and I believe that TechHive as privacy experts would have a lot of toolkits to assist in that. But you might need to consult externally or seek external advice from privacy professionals on how to conduct a valid DPIA. Effectively, essentially, it should be done, a DPIA should be done before a processing takes place. But if you are in the middle of a processing and you didn't even know about GDPR and data protection principles even in Nigeria before now, and you decide to conduct DPIA in the middle of your processing, it is still good as a privacy impact assessment. You're just looking at what you've done so far, how to improve on it, and all of that. It helps you to identify the risks. Oh yeah, I thought as much. So this was the slide before that I missed. So this is the definition of a data protection impact assessment. It is a tool for building and demonstrating compliance, where you employ a systematic process for assessing the impact of processing of personal data and the effect it has on the fundamental right to privacy of the data subject. So respect for fundamental principles plus management of risk is equal to compliance. And that compliance we're talking about is the DPIA. It is a tool that helps you, and it's really, really useful. It's really, really useful, to help you to identify the risk. What are we doing? What is the risk? How are we mitigating the risk? If anybody wants to call you tomorrow to say you're not complying as an organization in digital health, you can show them that. And if you realize that some of the risks are really, really high risk, you can write to the data protection authorities, either that is NICDA in Nigeria, to get advice. Because when a processing is essentially high risk and too high a risk, then that means it would affect the privacy of data subjects. You're not supposed to process that kind of data. But if it is medium risk, low risk, or even high risk, and you've taken enough steps to mitigate those risks, then you're fine. The mitigation is the key. It is when it is risky and you cannot mitigate it, then they will say no, because this data would really, really contravene data protection principles. Processing of this data might contravene data protection principles. So it's really important that you're able to conduct that DPIA to understand the level, the severity of the risk, and the level of the risk, and the things you have in place. How secure are your systems? What security measures do we have in place? What have we done to make our data secure so that nobody can hack in on our website and steal anything? Nobody can go and produce a replica of what we are doing on our website on their own, using things they take on our website. Nobody can steal your data. Or if you have followers on Instagram, on Facebook, that's another thing now. People just steal followers and all of that. You provide this kind of security measures to be able to make sure that you're doing the right thing, having the right technical and organizational measures in place for privacy and data protection. Yeah, so that is the second slide I was looking at before that says, when do you need a DPIA? And we've talked about that, especially when the processing involves innovative or technological solutions. So another thing is to look at, are we using technology? Are we designing a product, doing some innovations? Then this means we have to test the impact of this technology. Even before we start it, we have to test the processing we want to do. Are we going to use patients' data to develop some tools? Are we using patient information and patient data to develop some technological innovations? If that's the case, you really, really need to do a DPIA. And there are a lot of toolkits, like I said, you'll find, from privacy professionals on how to do it, what to do, and how to make it effective, because it's not really a big deal if you seek the right support. So begin to understand that by thinking about what you do and how you can make it better. So this is the life cycle of data of DPIA, just the life cycle. First, you start by describing, and that's the green color, describing the envisaged processing, assess the necessity and the proportionality, measures that you use to envisage and demonstrate compliance, assess the risk, mitigate those risks, document it, and then monitor and review. The very, very important things is documentation and monitoring and review. Because if anybody asks you, another thing is, do you publish your DPIA online? There's a lot of discussion around it. So if you have a very good online presence and you decide to publish your DPIA, remember, when it comes to the DPIA, you talk about the risk and the measures to mitigate those risks, security measures. So if you are already going to encrypt your systems and you're making it very secure, and you put all those documentation online, an hacker will know how to hack your system and they will know what to do. So it is very good if you just keep it within your organization, but always have it ready for review in case anybody asks, in case the data protection authorities ask. There's been a lot of controversies about publishing DPIAs, but my take on it is, it's because it has to do with a lot of security, technical, organizational measures that demonstrate compliance. It is going to be very risky to just make it public like that. But it might be available if somebody asks. That's a good thing, a way to signpost them on your website. Say, we've done a DPIA, this is good, this is tried and tested. And a very good example is, tools that are being developed around COVID-19 now in this current situation. You might be testing out some tools, some things, even, some testing kits and all of that. Make sure you do have that DPIA to be able to test, test proof your products or your tools or your technology before you deploy it out for people to use. And this is something that you must do for, even if you are maybe developing new drugs or new this, or depending on what you do in healthcare. Because what you don't want is to roll out something to patients, to people that you haven't tested it. And I'm not saying test the effectiveness, but test the process of making it. Not whether the drug is effective, but the process of making that drug. That's a big difference, because we're not doctors here. I'm not trying to say test your medicine or test. No, it is the process and the outcome to people. Those are the things that you conduct DPIA for, whether it has been mitigated, whether you have mitigated the risk, because we are looking at this from a privacy point of view and a data protection point of view, not a public health or medical point of view. So that clarification has to be there. And I hope we all understand. I know there are some questions here, but I will take them in a bit. Another way you can also set up your roles and responsibilities. Some of the roles and responsibilities you have is privacy notice on your website, because I'm sure a lot of us have a website presence. Make sure that you develop appropriate policies and procedures, not just privacy. Privacy is just, notice is just one of them. Procedures, either data retention, how long you retain your data from your organization. So if anybody is asking, it's been 10 years, you're still keeping my information, this is the reason. We have a policy. This is what we do. This is our policy. First thing is the privacy notice that talk about, some or all of the ways you gather information, you use it, you disclose it, and how you manage customer or client or patient data. Making sure that your privacy notice is clear for people to read. Don't make it a very long epistle, and that is why it will be good to work with people that know how to construct concise but detailed information on the way your organization, your company gathers data, the way they use it, the way they disclose it, manage it. Anything that has to do with patients, what do you do with it? Your privacy notice. Another thing is your subject access request. People will come to you and say, give me my information. I want to see what you even have about me. You must have a procedure for that. And these are some steps, some recommendations from the ICO. In a case where somebody asks you, you must respond within 1 month. You must give them that information. You must not ask them to pay for the information you owed about them. These are things that you have to make sure you follow as an healthcare provider. So it's quite interesting to see these provisions and these recommendations or roles and responsibilities that you must adhere to as an healthcare professional. So I put a little picture there that says a good privacy notice should tell you who is collecting your information, what it is going to be used for, and whether it will be shared. Those 3 things: collection, usage, and sharing. So even if you don't want to employ a professional, you yourself can sit down and write it, and then ask somebody to look at it and make sure it has those 3 information: collection, usage, and sharing of patients' data, or people that go on your website, just even if it's not just normal personal data, and put it on the website. Yeah. Now we go to other types of roles and responsibilities that you should follow as a healthcare professional, and that is staff awareness. All this will make no sense if you're not able to explain it to the rest of your team, because I'm sure it's not everybody here today that is coming here with the whole of their company. Some people have to be at work so that work can continue, and then some people come for training online and all of that. So staff awareness is really key. You must be able to create that awareness for your staff, have a team, conduct training programs, such as we are doing today. You take back what you've learned and tell the rest of your team and get further advice. Go for further training or delegate people that would need that further training and make sure you provide it. You can even set aside small pots of money or resources just for data protection training. Keep up to date with information. See what's happening now globally, follow the trend, follow the message, and try and improve on your own understanding and awareness of data protection. Or get a professional to train your team. Provide all those information for you so that you can be able to integrate privacy and data protection into your core operations. And that sets you at a high standard in a competitive market. Because you would find that a lot of people would be looking at, the first thing an international organization would do is, what's your company called? Well, they spam, they put it online. Oh, that's right. That's good. They go and look at your privacy notice. That's interesting. Your web presence, your digital presence would be enhanced by how much you take privacy and data protection seriously. There's no doubt about that. Because the world is transitioning. Nobody wants to put information on your website and then the next thing they get a knock on the door. Do you want to buy this? You know, so it's really, really important that you're privacy aware, your data protection secure, this kind of thing. So security is also another thing. I mean, in the Human Brain Project now, we have a team. We are now going to develop perhaps the position of a chief security officer, because security is something we take really, really, really seriously. We are just a group of researchers, about 500 scientists across all the EU countries that have been funded by the European Union. We have to make sure that, we are on top of our games in terms of security, privacy, data protection, demonstrating best practice, international initiatives towards that. So for small projects, small companies, small organizations, it will be interesting to see how much you can put into security. And there are different types of threats. That's something I must stress. You might have a threat, external threat of malware, hacking, people stealing your data, transferring all your patients or personal data. That's fine, or that's bad actually. But what about internal threats? Employees in your organization that actually want to access data inappropriately? Or do you think that because people work in the organization, they must have access to all the data? You must have different layers and login layers of data that will be accessible for different people, depending on the role and the responsibility to which they hold in your organization. It's not everybody that must have access to all the information because they are staff. That's another thing that you must also be aware of. So making sure that, because internal threats are sometimes even greater than external threats. You wouldn't know, people in the organization just stealing information, knowing that this is the next business plan that the company is planning to do, and they'll quickly go and do it and then sell it back to the company, different kinds of information like that. So there is that opportunity for internal employees that have that mentality to actually access health data. We've had stories. We see a lot of cases here where nurses might even go into the patient's record. Maybe the patient is a family member and they just want to know. They just go and take information, access it inappropriately that they are not even supposed to be privy to, just because they want to know. So those things might be a threat. Login layers, security is what would do that, to provide that kind of embedded layer of security to that information. Yeah. Then data breach is something that's, quickly I'll talk about because we're rounding up. Data breach notification. You must have the right procedures in place to detect, report, and investigate data breach of your clients, your patients. And obviously you have to do this within 72 hours or without undue delay. There's a lot of information around data breach that I can't go to, but sometimes you might need to notify your patients or your clients of the loss of their data or the breach of their data, but not all times. It's only sometimes. So, it's about liaising with the right people, but having a policy regarding it, but then also following the law. And I've put a picture there of what the law says, but it's always within 72 hours or without undue delay from when you find out about the breach. And the definition of a breach you find there, is a breach of security that leads to accidental or unlawful destruction, loss, alteration, unauthorized disclosure or access. Now, I must stress that in terms of data breach, unauthorized access to the data is a breach. It's a different thing whether you should notify authorities or not, but it is still a breach that you might want to note down into your own due diligence and organizational documents, records. Because anybody that have access to your data, either if a flash drive, memory card of your data, of patients that has to do with your organization, even if they don't use it, unauthorized access, even if they have not downloaded anything there, but they had access to it, it is a breach. Take, for example, you leave your flash drive in a car or in a bus, public transport, and somebody brought it home for you and said, oh, we saw this document and we saw your name on it, and this is the flash drive. And the person may not have touched it, but the fact is they had unauthorized access to it due to your own negligence. That's still a breach. I'm not saying you should notify all your patients now and say, hey, we left your data on the bus. So no, it is actually, you have to sit down and look at the risk involved to be able to see whether you should notify or not. But that unauthorized access, you should monitor it, write it down, log all data breach in your organization. It is good for your own audit, your own internal audit, auditing of your procedures, your processes, see whether things work or not. So it's very, very interesting and important for you to be able to understand what you should do in terms of data breach. And you can even have a small policy. It doesn't have to be a big epistle or something that you do, the steps you follow, have a map, have a trajectory of what you should be doing. But that is part of your roles and responsibilities as healthcare professionals. So finally, I think we come to the last question, after which I think I will now take questions from people. But if you want to put up the last question, that would be fine. I will stop sharing now so people can answer the very last question. And then we'll do a recap, and then I can take questions from people. Thank you. So that is in relation to data protection impact assessment. And it is which of these answers best describe what constitutes a DPIA? Yeah, I think that's good. People have answered that. So yeah, before I take questions, I'll go back to share my screen. And then I've seen some very interesting questions because I like questions. And thank you all. Keep them coming because it just makes me happy to know that people are thinking. I like critical thinking. And I think everyone here, you know, we're feeling it maybe as much as I am. So again, the answer to that is that a data protection impact assessment help organizations to identify, assess, mitigate, or minimize privacy risks with data processing activities. So A is the answer to that. That is what it does, you know, just to let you all know that, yeah, that's the answer. And I believe we all answered that really well. And we come to the recap. You know, we've been here now for nearly 2.5 hours and still going, talking about principles of data protection, the legal basis of processing sensitive personal data, how you manage your rights, and manage the rights of data subjects, and what are your roles and responsibilities. I really, really believe that this session has informed you of all those things in your roles and responsibilities as data processors, the data controllers in the healthcare sector. So I will stop sharing because I want to go to the questions that we have. And that's the only way we can test our knowledge even further here. So the question is, first question is, does Nigeria have a data protection council? Is NDPR 2019 similar to the draft data protection bill 2020? Thank you very much for that question. That is really, really, you know, good and critical. These are bills or legislations that sadly in Nigeria you find they keep emerging. When the government comes, another bill comes, a regulation comes, and without pointing fingers, I think Nigeria is in a transition phase, trying to make sure that they set best practices. I mean, I was at the workshop on Monday talking about the draft bill, and I could see that, you know, one of the things that the working group said was, you know, we've waited long to do this, even though other countries have done it in Africa, but, you know, arriving late doesn't mean we are not going to do it. And we are probably trying to learn from other countries to do it better, if not best. So many of these legislations have some discrepancies. And if I start with the, you know, with a lot of issues around them, we will not live here today. But they are all similar and they point towards the same thing, regulating privacy and data protection in Nigeria. What we should understand is that the 2020 draft bill is still open, is not yet law. The NDPR itself is a regulation as well. So we are still at the stage where Nigeria is still unfolding the parameters of privacy and data protection. And they are similar, but they have a lot of discrepancies. There are some missed opportunities in the regulations that perhaps haven't been included. It will be good to draw insights from international countries that have done, that are at the forefront of privacy and data protection, but understand that the peculiarities and institutional configurations of Nigeria would mean that they need to adapt any international law to their own local configurations, because Nigeria has a lot of peculiarities. For example, consent. Provision on consent must be available in different languages. A lot of Nigeria has over 300 languages. So there are many, many discrepancies in those regulations, but they are all pointing towards the same thing. So I hope that answers your question. And do we have a Data Protection Council? Not that I know of. I know we have NICTA, which is an agency. They haven't used the word council. I know that the draft bill was supposed to talk about, was supposed to establish a Data Protection Commission, and it gave it a lot of powers and independence, and that is even controversial. So it remains to be seen. Another question the same person asks is, how can a doctor build a career in medical law and ethics or medical law? Interesting. So medical law and ethics, you can study it in your master's. We have it in the Montfort University here. It's very interesting. I think it's an online or part-time program, I'm not sure. So it is something you can study. I didn't do medical law, but I do a lot of medical law and ethics now in my role. So it's something you can study on itself. It's something you can study as part of law and technology as well, because there'll be a lot of medical law that depending on what area of technology you want to go into, digital technology, health informatics, neurotechnology, and all of that. As part of the technology you look at, there are different aspects. So there's a lot of options for you. It will be a case of sitting down to see what trajectory you want to become as a doctor. And I can have this conversation with you offline if you want, to understand where you want to go and then see what options you have there. So that is that. I hope you cannot hear me. Somebody has raised up their hand. I'm trying to see who it is, but if you want to talk, maybe the person can be Emmanuel, if you can be unmuted. I think they are muted. Yes. Can we unmute Emmanuel? Can we unmute Emmanuel? I think you're muted as well. Okay, I'll try and see if I can unmute you here. Okay. So another thing the person was asking, I don't know if you can hear me. I hope you cannot hear me. Somebody said, please, you mentioned that privacy and security is different from privacy and IT. Is privacy and security more related to the field of law? So in terms of that, I don't know if everybody can still hear me. In terms of
yes.
privacy, okay, thank you. So in terms of privacy and security, the reason I say that privacy is different from data protection actually is because privacy is the overarching measure here. Data protection is only part of privacy, and that is something I wanted everybody to be aware of. So that's why I say that privacy is different from data protection, and privacy is also different from security. Security can form part of privacy, but when we looked at privacy at the very beginning, we see that privacy is, there's a lot of things in privacy. In other words, rights to private life, family life without interference and all of that. So all of this, you know, they are different from security is just one aspect of it. So when we say privacy, some people say, oh, IT, oh, security. All those things are just one of it. Or data protection too is different. All these things, they might be interwoven, but they are actually different. And that's what I wanted to clarify. So they are not just the same thing. And it's not like it is more related to law. It's just, you know, data protection might have a lot of legal undertone to it, even privacy as well. They might all have, but the operational systems attached to it in terms of IT security may not have anything to do with law. They are just technical and organizational measures that need to be in place. So that's different. Also, what is the process of becoming a data protection compliance organization in Nigeria? I think Ridwan would have more answer to that, TechHive, because they have, you know, that's information and they are situated in Nigeria. But I understand that you probably need to go do some certification courses and pay some registration fee and be actually, you know, at the forefront of it. So you must be inclined in that respect. You must have that experience, knowledge, and expertise, and then obviously follow the process of registering. So then, is there a field of study that deals with data issues, particularly health data? So ethics, actually, it depends on the type of ethics, as long, you know. So ethics and compliance. In my own role as DPO, I lead a task on data protection, data governance, compliance, and data management plan. So privacy, ethics, and responsibility is really integral to what I do. So the field of study would probably be ethics, you know, ethics of emerging technologies. If you want to look at that, that's something you can study. You can study law and emerging technology. If you want to do it with law, if you want to do it just on your own, you can study ethics of emerging technology in cyber, in computing. You know, there is that's in De Montfort. So if you're interested, let me know. And that is that. Then there's another question that says, what particular security measures should I take to ensure data protection on my platform? So we've talked about privacy notices and all of that. Those are the legal measures. The security measures, unfortunately, I'm not a security officer. The security measures would be speaking to tech people to sort of, you know, help you with encryption layers, login layers, making sure that your data is not easily accessible. The legal measures, those ones you need to, you can always, you know, you can always do that because they are online. You can find the law and make sure you sort of follow the law. But then the security measures, you need a security expert, people that can go into do some penetration tests on your platform and see how difficult or easy it is for hackers to go on your website and tell you what you need to do. Yeah. So that's the real, you know, the security measures. Then, yeah, we've talked about that. And could you post your question? Okay. Oh, yeah, I think we couldn't hear Emmanuel. I know he raised up his hand before. So if you want to, you know, talk or you want to post your question, let me know. I'm just waiting to see if there's any more questions, if we have any questions as we wrap up. And I will try and share my screen again just to give you some final thoughts. And if you want to, I think we've talked about all of this. So we're coming to the end now, question time, and otherwise, I think what is left is to say thank you. So, I mean, I'm doing this in alliance with TechHive Industry, TechHive Advisory, and I'm hoping that if you have any questions, you probably contact them. If you contact me as well, I've put my information there for you. And I really hope this has been very, very useful in sort of demystifying the questions you have in terms of privacy, data protection. I think there's another question here in the chat, which I can try and look at before we round up because we're coming towards the end. Let me see if there's any question. No more question. Okay. So yeah, all that is left to say is thank you very, very much to everyone. Thanks for sticking around. And I think if you have any questions, I must also say that Digital Health Nigeria has been very, very useful in organizing this. And I have to thank Dr. Wale Adeosun, who has put this together. This is something that I find really, really passionate for me, because I think Nigeria is getting into a data society that would be really, really useful for us in the digital health platforms. So if you want to reach out, I'll put the details there for you to reach out. I'll probably do that again. And you can also contact Digital Health Nigeria. I think they have their own websites that they'll probably share in a bit for you to be able to sort of get more information. So I'm going to stop it there. And thank you all very much, and I'll speak to you soon.
Thank you so much, Dr. Akintoye, for that very insightful presentation. I'm pretty sure that we've all learned a thing or two or more from your presentation, so thank you very much. At this time, I'd like to hand over to our next facilitator, but he'll mainly be speaking during tomorrow's session, but he would like to make a few contributions at this time. That is Mr. Ridwan Oloyede. So over to you, sir.
So I think the last one is your Ugo, you can make your contributions. You want to do that.
Hello?
Hello, Ridwan. We can't hear you properly. Since you started talking, we can't hear you properly. No, there's a certain static. We can't really hear you. You seem quite far away from your mic or speaker.
Is it better now?
Come again?
No?
You're still breaking. You're still breaking.
That will possibly have to do with the public quality of the network I have right now. But I'm not certain if you can hear me now. If it's better now here.
Yes, we can hear you now.
Thank you very much. Yeah. All right, thank you, Dayo. Thank you very much, Dr. Simi. For breaking it down and making it as simple as possible. That looked more like a one-on-one, even for me, who has been working around the space. Thank you very much for that wonderful contribution. So just before I dive right into making my own very short comments, I know Emmanuel Ugo, if you can unmute yourself and probably push your question to Dr. Simi. If you can unmute yourself and still make a contribution, if you still intend to, you are able to do. You should be able to do that now. Yes, if you can unmute yourself, please.
Yeah, I've done that. Thank you very much. Good afternoon. Thank you very much for the invitation. It was quite an eye-opener, as I said, quite an exhaustive lecture. Oh, people can hear me. Hello? Can you hear me? Okay.
Yes, we can hear you. We can hear you.
Yeah, thank you, Dr. Simi, for the presentation. Quite exhaustive and quite informative. And as you said, in Nigeria here, we are still in the infantile stage of the digital processing and preparing documentation. My question is, I'm a doctor, I work in the hospital, and mine is actually on patient right and subject right, because it seems as since most of our patients and subjects don't know their rights when it comes to data information or what we have said this afternoon. So I'm looking at, do you have anything, is there any aspect of your work that you're dealing with patient awareness, making patients aware of their rights so that they can actually juxtapose or at least engage the organizations when their rights are being breached? Like in the hospitals, most patients come to us, they don't know their rights, they might be bullied around and not told a lot of things. So is there anything that you're doing towards patient awareness so that subjects can know their rights when they come to the hospital and they can actually sit up to that? Because in Nigeria, this they passed this bill of patient rights in this country. So most people don't know their rights. So what are you doing in that area? Thank you.
Thanks very much, Emmanuel. And I think this is a really good area for patients to know their rights, especially when they're going to consent for their data to be used either for research, for treatments, or whatever. So in the Human Brain Project, what we do in terms of that, because we don't liaise with patients directly, we liaise with scientists that do research on patients. So we liaise with, hospitals, and these hospitals, we hope, have collected all the necessary information and also provided as much awareness as possible. Being a developed country, we may not be faced with questions that you've raised here in terms of awareness, because patients know their rights. They are even more aware than the researchers, But for developing countries like Nigeria, the best thing to do is to create that atmosphere, that safe atmosphere. And because my husband is a doctor, for example, and he worked in Nigeria for years. So I know that, doctors are seen as, you can't talk, you can't, so patients get scared of their doctor when they see their doctor, because they might think you would not, if I complain too much, this doctor would not see me, and I really need this treatment, so I have to act, as if I consent to everything, even if I don't. It is just creating that educational awareness. And we've done a lot, even though we don't liaise with hospitals directly, we still make sure we create awareness around us. So conferences, community building, engagement, trying to include patients in our survey, even though we don't deal with them directly, we try and do some post surveys. So if in the hospitals, maybe you do some things like feedback forms, give that to patients. How did you find us today? Did you like the way you were treated? What would you like us to do differently? And then you can build on that and just do an awareness day where patients are treated, and you call them together and speak to them, tell them about their rights. This is what you can do whenever we treat you. These are the things we ask you to consent to.
I've lost you. Hello?
Sorry, I think I got muted. Yes, yeah. Signposting them to the right place, letting them know what they need to know, signposting them. But again, starting with that kind of environmental scan, doing an analysis, like a feedback. Just, when they come to your organizations, just a little form or something that will not be too much, just yes, no. In the UK here, they use like smiley faces. They'll just say, how did we do today? And they'll put a smiley face and a sad face. Just ask them, even if they cannot write, let them just tick which one they feel, so that you know whether or not they know what they're talking about. Or you even give them, a list of, do you think you know your rights? Do a questionnaire and see whether they know. And if you realize they don't know, then it's just a case of doing an awareness around it. And you come to the hospital, give them some information, do some leaflets, some pamphlets, just, give to them, know your rights, this is what you can do. You don't really have to do this. You're the one in control. We are just here to help you and support you with health. And this is where you seek further information. So you give them that sort of opportunity for further information. Complaints procedure. So maybe a pamphlet, raise awareness rather than organizing a big event and they may not even come. So maybe a leaflet, pamphlets, let them get information.
Okay. Yeah? Thank you very much.
Thank you very much for that, Dr. Simi. So just by way of an addition, I'm also trying to, I know there was a question around the fact that maybe the session was more GDPR centric and what applies in Nigeria. And as she's rightly said, a sizable part of, aside the fact that